Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be talking about trusts, who needs a trust, and what exactly they are involved, and their consequences, good or bad. And our guest is Jeffrey S. Greener. He's the partner at Rifkin Radler, one of Long Island's largest and most prominent law firms located in Uniondale, and he's also the chair of their Trust and Estates Department and involved in wealth transfer planning. Jeff, welcome to Law You Should Know.
Thanks for having me.
I imagine most of our listeners don't know exactly what a trust is and why and for whom it's very important. So just tell us about that.
So trusts can be a very effective estate planning tool, but they're often misunderstood because there are so many different kinds of trusts. A trust is basically an agreement between the grantor, the person who funds the trust with money or property of some kind, the trustee who holds the trust assets, and the beneficiary or beneficiaries for whom the trust assets are to be held.
And that trustee holding the trust is also going to manage the trust.
Correct. That trustee has certain fiduciary responsibilities to both the trust assets and to the beneficiaries whom he or she works for.
And we'll talk about it in more detail, but that could be a financial institution. It could be an attorney, someone like yourself, or perhaps another relative who's considered trustworthy or reliable.
Exactly. Family, friend, professional advisor, or a financial institution.
Okay. And the trust will also help minimize taxes to the trustee, the person whose assets they are, and the beneficiary who's eventually going to receive the benefits of the trust.
In many cases, you can break trusts down into a couple of different categories.
Okay.
There are revocable trusts and irrevocable trusts. Revocable trusts really serve as a will substitute. They're meant as a way to have your assets pass to your intended heirs when you want, how you want, to whom you want, typically at death. And the primary purpose is to avoid probate. By themselves, they don't offer any greater or lesser tax savings than a will or other transfer.
And some people feel it'll be quicker than probating a will and going through the surrogate's court, and you'll avoid taxes if there are any taxes.
Sure. All things being equal, they ease administration, they lower costs, they make planning for disability a little bit easier. So in a perfect world, a living trust or revocable trust, as we call them, can have advantages to a will. The big issue is transferring assets to the trust while you're alive to make sure that it's effective.
So it must be done by someone when they're still competent to do so.
Correct. Once a trust is created, sometimes another individual with a power of attorney would have the power to fund a trust, but this is something that you should do while you're able to do so.
So this is very important for someone who might want to be covered by, like, let's say, Medicaid down the road.
Well, not exactly. A revocable or living trust is basically indistinguishable from yourself. It's sort of like one's alter ego. An irrevocable trust is one where the grantor or the person funding the trust steps away from the trust and has fewer or no benefits. That might have both tax and Medicaid planning benefits, and that's increasingly popular.
And that's the irrevocable.
Right. Specifically, we in our practice, we call those irrevocable income-only trusts because there are so many kinds of trusts. We give them names or acronyms to help ourselves and our clients understand what kind of trust it is.
And you're really divesting control of your assets or property to the trust.
Correct. With an irrevocable trust, you're giving up control to a trustee other than yourself.
So what are some of the situations in helping a person decide whether they need a revocable versus an irrevocable trust?
So if an individual has neither a will nor a trust, one or the other is an effective way of transferring your assets at death. If you don't lay out the roadmap in the form of one of these documents, New York State will make one for you. Their rules of intestacy will guide who gets your assets after you're gone. And the people that New York chooses may not be the people that you choose. So creating a trust will let you, again, pick who gets your assets when and how.
Now, are there more startup costs, let's say, to create a trust than there might be in writing a simple will?
The trust is often done in conjunction with a couple of other documents. So typically, we'll create a will also, at least when we're working on revocable trust. We call that a pour-over will, P-O-U-R. That's just sort of a belts and suspenders arrangement. So in the event you haven't gotten all your assets into the trust while you're alive, the will pour over into the trust all those assets, so everything's in one pot, so to speak.
And if you have an irrevocable trust, can you change the person who's the trustee?
You can retain that power. There aren't many powers you can retain in an irrevocable trust because the benefits of that trust are typically asset protection or estate tax savings, and you as the grantor want to distance yourself from the trust. But you can reserve the right to remove and replace trustees, which is a very powerful tool in itself, and still not have those assets brought back into your estate.
Can you change the beneficiaries of the trust in a, let's say, irrevocable trust?
In some instances, if the trust is drafted broadly, you can do so. One way is to create a class of beneficiaries and perhaps give the trustee or a third party the ability to choose who among that class will share in the estate. You can build in what we lawyers call a power of appointment to direct which one or more of those beneficiaries will inherit. And an increasingly popular choice with trusts that have already been created is decanting a trust, where like a wine, you can pour the contents of one trust into a different trust with different terms, provided the first trust allow you to do that or you qualify under law.
Without doing these things, would a trust run into any difficulties if, let's say, your children or grandchildren changed, your spouse changes?
Sure. You may be estranged from one or more of your children. One child may run into financial or family difficulties. And if the irrevocable trust already directs how and when they're going to get those assets, there won't be much you can do to protect them from a creditor or a divorce or other situation.
And is a trust generally the both spouses have a trust, or it can be done by just one spouse?
It can be done by one or both. Sometimes trusts are reciprocal in nature that benefit one another, although there are rules that go along with that. It's a pretty flexible arrangement. Trusts have been around for hundreds and hundreds of years. They take many forms and can be a great tool when used effectively.
And so just in recent years, why are they becoming more popular?
So the revocable trust is becoming popular because people want to avoid probate, and all things being equal, that's great. Again, the key is getting assets into the trust while you're alive. Now we see more and more irrevocable trusts for Medicaid planning purposes. People are concerned with the high cost of nursing home coverage, and they like to protect those assets from attachment.
And is there an appropriate age for someone to consider a trust? Is there any age? Or?
I like to think when people have settled down and they at least believe for that moment that they're family is fairly well settled and their finances are well settled, they can make an informed decision. Perhaps they've reached a certain level of maturity, 50s, 60s, and beyond.
And is a probate a dirty word, or if you're not sure you will have to go through probate, isn't necessarily a bad thing?
Not necessarily. If your assets are fairly straightforward and your family is fairly typical, if you can call any family typical, probate in Nassau or Suffolk, for instance, is a pretty smooth process, not very costly, and shouldn't take too long.
And under most trusts, you can still stay in your home and go about your affairs?
Absolutely. Certainly with a revocable trust, that's your alter ego, so you can do everything with your home, finance it, sell it, buy it. With the irrevocable income-only trust that we use for Medicaid planning, here too you can stay in your home. No one can ever force you to sell it. But if the trustees agree to sell it with your permission, they could do so. With those trusts, it may be harder to get a home equity line or reverse mortgage, so one has to be really careful before placing their home in a trust.
Would you also qualify for property tax exemptions, either for owner-occupied or senior exemptions?
One of the tremendous benefits of this Medicaid-type trust is that for income tax purposes, nothing has changed, nor has anything changed for real estate tax purposes. So you keep your STAR exemption, your senior citizens exemptions. If you sell the property, you get your Internal Revenue Code Section 125 capital gains exclusion. The benefits of this income-only trust, I think the benefits far outweigh the drawbacks.
If there's a lender involved, if you have a mortgage or something, which may have something to say about who is owning the property or paying taxes, would a trust matter to them?
Yes, very much so. With a revocable trust, it wouldn't matter at all. But with an irrevocable trust, lenders would want to know before you place your asset into an irrevocable trust and might not allow it. And then again, if you took a home that had no mortgage and you put it into an irrevocable trust, you'd have a very difficult time finding a lender to give you a mortgage after the fact.
So that's a big caveat. If your property is you have a big mortgage on your property or a second mortgage, there may be some preliminary conditions before you can just jump in and have a trust.
Absolutely. It would technically be a default under your mortgage to transfer the property into the trust without telling the mortgage company. And with these irrevocable trusts, someone down the road might want to pull out some money in the form of home equity or a reverse mortgage, and you could no longer do so.
Okay. And are there other considerations in revocable versus irrevocable?
Revocable trusts are far more common, and more people would find them useful as an estate planning tool. Irrevocable trusts would be typically for asset protection or estate tax planning.
And over what, let's say, income are you more concerned about a revocable trust where it might be benefit to you?
From income levels, I'd say everybody should have some type of an estate plan. You should direct who gets your hard-earned dollars after you're gone. So from an income tax point of view, it doesn't really matter. From an estate tax point of view, now with the both federal and New York State estate tax exemptions rising so high, New York is over $5 million. The federal exemption is over $11 million. Far fewer of us have an estate tax problem that we're looking to give away assets for that reason.
Okay. We're going to continue our discussion in a moment with Jeffrey S. Greener, who's chair of the Trust and Estate Department of Rifkin Radler, one of our most prominent and largest law firms here on Long Island. And we'll talk about some other considerations involving trust and who needs them, and it's good information for everyone to know. You are listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at nccradio.org.